Let me break this down for you in the thickest legalese, so that way only the best and brightest can understand what the hell I'm talking about. Over and over again, magistrates in America have wrote up a facts and recommendation report on dispositive measures. And then the Article 3 district judge customized the report's conclusions to the district judge's liking. In Doe v. University of Michigan, ED Michigan 22, a 2020, a magistrate's finding and recommendations report proposed to deny summary judgment on a due process claim, which was reviewed and adopted by the district court, illustrates the standard process. So when it comes to the power of the magistrate, if the issue at hand can dispose of the case, they cannot rule upon it. So they cannot rule on anything with finality. What they can do is issue a facts and recommendation report. And they want to try to say that the goddamn fucking verdict is the facts and recommendation report. That's what they're trying to say. Well, she went ahead and dismissed the summary judgment. She went ahead and dismissed the goddamn discovery. She dismissed 45 of the fucking things because government can do whatever the fuck they want to do, so they're just going to go ahead and give fucking immunity to any goddamn government motherfuckers so they can fuck over anybody and everybody that they feel like, because fuck you. If you're an American citizen, you're a peasant, you're a fucking nobody, you're nothing. Your citizenship don't mean shit. You might get fucking goddamn deported to goddamn Sikot in Guatemala, maybe get deported to fucking Sudan or some other goddamn concentration camp. You're fucking nothing. Even if the lowly government, even if the goddamn local dog catcher wants to fuck you the fuck over, he gets immunity. He's the government agent. He's a dog catcher. Yeah, you better pay attention, Freddie Fred. In Ortiz v. Jordan, 2011, a magistrate recommended that summary judgment be denied over genuine issues of material fact, and Article 3 district judge reviewed the findings and recommendations report de novo and adopted the recommendation. In order to do a de novo review, so let's say the magistrate actually has a big fucking loophole, right? So the magistrate can't do summary judgments. The magistrate can't do anything that will dispose of the case. They can rule on all these tiny little things over here and over there. They can help manage the caseload. They can help streamline the case. They can go ahead and say, all right, here's the facts of the case. Here's the laws that are at play. Go ahead and organize the case for the district judge. And if they decide on a dispositive issue, they can write up a facts and recommendation report. But instead, what these damn magistrates are doing is they're going ahead and pretending that they're district judges, and they're going ahead and making the fucking verdict right there in their goddamn magistrate court. And you think they're going to, what, go along with right or wrong? You think they care about what's legal and what's not legal? They don't give a shit about the facts. They don't give a shit about the law. If you're pro se, they say, fuck you, your life don't fucking matter. They'd rather they'll believe the lies of a lawyer than they would the truth of a citizen. So 28 U.S.C. 636B1B, they have a big loophole. They can go ahead and make the big decision, the dispositive decision, and say, you know what, we're not going to do summary judgment. We're going to dismiss summary judgment by a facts and recommendation report because of A, B, C, and D. The law doesn't say that it should happen. The facts don't say that it should happen. But instead, it's like, I don't want to do it. Well, that's a facts and recommendation report. I think the summary judgment should be dismissed. That's not a facts and recommendation report. That's just you goddamn fucking farting out opinion. Farting out a fucking judgmental fucking opinion without the facts and without the information, without the goddamn law. The Supreme Court held that a denial of summary judgment based on factual disputes as recommended by the magistrate cannot be appealed after a trial unless preserved through a Rule 50 judgment as a matter of law motion. Why? Because the factual record developed at trial supersedes the record existing at the time of the summary judgment motion. Therefore, a party must raise a sufficiency claim in a post-trial motion in order to preserve it for appeal. The Rule 50 motion for factual sufficiency allows the district court to take the first crack at the same question that the appellate court will face later on. Was there sufficient evidence in the trial record to support the jury's verdict? In Dupree v. Younger, 2023, the magistrate's recommendation was pivotal, but the district judge's adoption of the magistrate's recommendation was the final judgment. In Houskins v. Sheehan, 7th Circuit, 2008, a magistrate judge recommended denying a summary judgment due to disputed material facts, and the district court judge adopted the recommendation. The 7th Circuit in Houskins v. Sheehan ruled that denials of summary judgment are generally not reviewable post-trial. Over and over again, interlocutory appeals were used to appeal an extrajudicial dispositive decision made by a magistrate. In the case in re-cement antitrust litigation, 9th Circuit, 1982, a magistrate judge's discovery order in a civil case was overruled, declared invalid by the appeals court through an interlocutory appeal. In Alanis v. California Processors Incorporated, 9th Circuit, 1982. An interlocutory appeal was filed against the magistrate judge for an ultra vires order in a civil case that didn't have consent from all the parties. You want to have absolute power? Then get fucking consent from all the goddamn parties. The only way you can get consent from the goddamn parties is if you are just notoriously known for being fair and honest and good and balanced and in Osband v. Woodford, 9th Circuit, 2002, the Federal Appeals Court overturned a magistrate's ultra vires order of denying appointment of counsel in a habeas corpus case under the collateral order doctrine, since it was separate from the merits and couldn't be effectively reviewed later on. In Reynaga versus Camisa, 9th Circuit, 1992, a magistrate's ultra vires dismissal order was overturned by the 9th Circuit Appeals Court and declared invalid since the order was dispositive. The appeals court came by the case through an ordinary 28 U.S.C. section 1292B interlocutory appeal. A dispositive order functions as a judgment. Is it final or near final? And therefore, a dispositive order can be appealed directly to the U.S. Court of Appeals. U.S. v. First National Bank of Rush Springs, 10th Circuit, 1978. Also look at the Federal Rules for Civil Procedure, Rule 54A in First National Bank, 10th Circuit, 1978. The court noted that the standard of review was de novo for legal issues and clear error for factual findings. De novo for legal errors. So that would mean the magistrate writes the report, the recommendations report, the facts and recommendations report, and the district judge takes it back to the beginning, takes it back to zero, and judges it on a clean slate. So the district judge isn't just going to rubber stamp the fucking magistrate. The district judge is going to take in the totality of the circumstances. And the magistrate hasn't asked for any facts. The magistrate hasn't asked for any goddamn law. The magistrate is just saying, oh, he's pro se. He's just a fucking American citizen. Fuck him. Who gives a shit? We're federal fucking courts here. We're better than all you stupid ass plebeian fucking American citizen piles of shit. Your fucking lives don't matter. Why do we have federal courts? Just so the fucking lawyers can make a shit ton of money, so the corporations and the rich and the powerful have a fair place to resolve their disputes, but we, the people, don't have a fair place to resolve our disputes? How is that fair? That mirrors that for judgment orders from district judges of magistrate decisions. So de novo for legal issues, clear error for factual findings. Here's some factual findings. Is it